Good evening. My name is Barry Gleason, and tonight I'd like to go over the terms of use agreement that Priceline.com is currently in effect. I must admit, like most of us, I very rarely read terms of use agreements or privacy policies, but after participating in this assignment, I will start making it a habit to review them closer from now on for the sites I do business with. It was extremely eye-opening after I read through Priceline's terms of use how much control and power these companies attempt to claim in both their privacy policies and terms of use. Priceline, like most other companies, simply put a caveat in their terms of use that if you don't agree with the rules, policies, and regulations that they are publishing, your only right is to not do business with the company. Some of the key points from the terms of use policy that jumped out at me and that I'd like to briefly discuss are the following. This website, along with the Priceline.com mobile site, mobile and tablet applications, is intended for personal, non-commercial use. Non-commercial use. This I found difficult to comprehend. The whole idea behind Priceline.com is it's a site where users go to book hotel, airfares, vacation packages, and rental car bookings. How can this be considered non-commercial? This was the first bullet of their policy, so I was intrigued to see where Priceline went following this false statement. Priceline starts off by explaining that the user, or you, agree to be legally bound without limitation, a very broad and encompassing statement, clearly stating that Priceline considers this terms of use a binding contract, even though you or the user doesn't click on an agree button, sign his or her name in an agreement, or even checks a box stating that you read the terms of use policy. This, in my opinion, would not be a binding contract, and I state this per the court case Schnabel vs. Trilegent Corp. The background of the case was the father and son, whose last names were both Schnabel, signed up online for a program that provides discounts on products, services, in consideration of a monthly fee. Following the Schnabel's enrollment in the program, Trilegent sent out an email with additional terms and conditions, including and mandating arbitrary provisions. I use this example because Priceline has the same provision in their terms of use. They mandate arbitration to resolve any issues, not allowing small claim action courts of any kind. They go on to state, all claims filed or brought contrary to this shall be considered improperly filed and void. Priceline is actually attempting to take away your right to sue them in any other manner than they propose. After paying multiple months of membership costs to Trilegent Corp, the Schnabels decided to cancel their membership and sue for all their past membership costs. Due to it not being handled in arbitration, Trilegent considered it not in agreement with their terms and conditions and did not recognize the suit. So ultimately, in the Schnabel vs. Trilegent Corp case, the district's courts concluded that Schnabels never agreed to the additional terms and conditions, so they were allowed to pursue their case in small claims court. From the findings from the district court, you as the user would be able to sue Priceline. Having said that, understand that if Priceline did a better job handling how they distribute their terms of use and privacy policy, then they could avoid litigation. There are two ways to have emailed terms and conditions and website page policies binding them. There are two ways to have emailed terms and conditions and website page policies binding. These are after receiving actual notice or at a minimum inquiry notice, meaning sufficient information as would cause a reasonable person to inquire further regarding the terms, and manifested their assent or agreement with the terms of use by e-sign, e-verification, preferably, and this is where you are responsible for typing your name in a box stating you have read and agreed with the term of use, or by clicking an I agree box, or even better yet, both. That would be the number one change I would incorporate in Priceline's terms of use. I would make sure they included a box to type your name in and a box to check stating you read the terms of use and privacy policy prior to using their site. I would also suggest that once an individual creates an account with Priceline.com, the first page they are brought to is the terms of use and privacy policy pages before they are authorized to make any purchases. There would be a policy that allows customers to write into Priceline with any issues or concerns pertaining to the policy, and those would be reviewed by the company and possibly be added to the policy at a later date. This way, Priceline could build some solid feedback from their customers and show them that they care about their customers' rights and opinions. Priceline goes on to state in their policy that if you disagree with the arbitration policy, you must notify Priceline in writing by certified mail within 30 days of your first purchase or before you start to use the site, whichever is sooner, and then Priceline will prohibit you from using the site. Now, does this make any sense? So we have to write a letter or a memo, send it certified mail to Priceline to only have them then go and prohibit us from using their site. What is accomplished by this? Why wouldn't we as the customer just not do business with Priceline and avoid having to write them a letter and be prohibited from the site? The policy should be removed immediately from the terms of use page. In the user comments, feedback, and other submissions section, I found some interesting policies as well. For one, by submitting, transmitting, posting, uploading, you give Priceline the right to adapt, modify, exploit, distribute, and/or translate. In other words, they now own your content, which I found to contradict copyright law. I was under the notion that once someone wrote down a thought and it was shared with others, it was considered their property. Priceline goes on to state you will receive no compensation for your comments, posts, or pictures, and that Priceline reserves the right to monitor, review, alter, edit, refuse to post, or remove any user's submissions. I can fully understand if somebody's being rude or posting racial or sexist comments, but again, Priceline creates this powerful, encompassing policy that puts an extreme amount of power and control in their hands. I have to admit, after reading these terms of use, I got the idea that Priceline just wants us to pay them, smile, and behave. It was really quite amazing and educational, to say the least. I did find one other policy that replied related to one of our discussion posts. I wanted to share that, and that was the topic of ISPs being responsible to report the identity of bloggers or individuals that make comments on their site. Priceline makes it clear that they will fully cooperate with any law enforcement authorities or court order requesting Priceline to expose individuals' identities for their posts or submissions. No anonymity with Priceline. So, what should Priceline do, you ask, in addition to my earlier suggestions? Well, there are 4 main things they can do that will improve on confusion and issues down the road. Number 1, provide clear and conspicuous notice of all terms. Number 2, require counterparties to scroll through to the bottom of the terms and then type in their name in a signature block. Click I agree button or otherwise expressly and actively manifest their assent to the terms. Number 3, prohibit any use of the website or commencement of the relevant services prior to such express and active manifestation of assent. 4, periodically have counterparties reconfirm their agreement to the terms. So in conclusion, some of the main takeaways from this presentation I want to drill home is currently Priceline's terms of use is very flimsy in respect to it being considered a contract in a court of law. We discussed this in the reference to the Schnabel versus Tri-Legion court case findings. Secondly, Priceline would be doing themselves and customers a great service by making sure potential customers are shown the terms of use and privacy policy prior to them making their first purchase, and either e-signing the document, checking a I agree box, or better yet, doing both. Lastly, according to Priceline's terms of use, you are not able to sue them in a court of law because they have dictated in their terms of use that they will only recognize the arbitrary provisions. Having stated that, if we find that this terms of use is not a binding contract, which I think we would have a strong shot at doing so, it would not be valid. Thus, you as the user could in fact sue Priceline if you had a relevant grievance. I want to thank you for taking the time to view my thoughts, and I look forward to speaking with you again. I'm Barry Gleason. Have a wonderful rest of your evening.